If you blinked in July, you missed a lot of immigration updates. A judge in Boston blocked the administration's $100,000 H-1B fee again. A century-old rule that allowed student visa holders to remain in the U.S. as long as they maintained their status and remained enrolled in schools just got scrapped. TPS protection for 2 countries were gutted in the month of July. And ICE has posted its highest arrest numbers in its 23 years of existence. I'm attorney Lilian Chukwurah. I'm a U.S. immigration attorney, and I will be breaking down all the updates that you may have missed in the month of July so that you know going into August exactly what to expect and what rules apply right now. But before we get to July, let's touch base in June, because the end of June brought along Supreme Court decisions that do carry forward and led to the things that happened in July. On July 25th, 2026, the Supreme Court handed the Trump administration 3 wins in one day. It ruled that TPS terminations are largely shielded from court proceedings, meaning you can't really go through the court process to stop the government from ending TPS. It also ruled that asylum seekers do not count as having arrived in the U.S. unless they are actually on U.S. soil, which means that if they are stopped at the border from entering the U.S., they are not considered asylum seekers and cannot apply for asylum in the U.S. And 3, it gave immigration officers more room to scrutinize green card holders coming back into the U.S. from abroad. And then 5 days later, it handed the administration a real loss, which is on birthright citizenship. The administration wanted to do, through executive order, limit who qualified for birthright citizenship. And the Supreme Court said, no, you cannot do that through an executive order. However, there is something of concern in some of the dissent and the discussions that were happening around birthright citizenship with the Supreme Court. It seems that some of the justices would have been okay with the limitation if it went through Congress, but they would be okay with it if it was not a constitutional amendment, which typically, if you're trying to change a constitutional right, you will need to go through a constitutional amendment. But it seems that they may be open to it if it was through a congressional action instead of an executive order, but not requiring an actual constitutional amendment. And of course, right after that decision came out, there is now a bill trying to be pushed that went specifically on birthright citizenship, trying to have a congressional action on that executive order. So basically turning that executive order into a congressional action, and then seeing, again, it's going to lead to a lawsuit, but based on the decisions and the discussions by the Supreme Court justices, they may be open to letting Congress make that decision versus the president doing it through an executive order. We will have to wait and see if that legislation actually has any traction, but it is something to keep in mind and keep an eye out for. On July 16, 2026, the Department of Homeland Security, DHS, issued a rule rescinding the 2022 public charge rule. This is basically the rule that made it so that if you receive some types of public benefits, you would still qualify for a green card. But by rescinding that rule, it basically leaves it open for the officer to look at any public benefit that you received as a negative factor in determining whether you would be a public charge or not. Here's what's changed. So the old rule gave officers a pretty narrow list of benefits that they can consider when making a decision on whether the person is going to become a public charge or not. By rescinding that rule, the officers now have broad discretion. They have to look at the totality of the circumstances to determine if the person is going to become a public charge. They are not limited on what they're going to look at in order to make that decision anymore. So if a person has received Medicaid, SNAP benefits, or housing assistance, all of those things, even if they qualify for it at the time they applied for it, would now be taken into account when making a determination of whether they would become a public charge and whether they can receive a green card. Here's the important thing to know about this rule. It does not go into effect until September 18th, 2026. So it's still August. So make sure that if you have had any public benefits in the past that would now be open to the public charge rule, that if possible, apply for your green card before September 18, 2026, so that you will be covered under the old rule. But once it's September 18th, if they receive your application September 18th and after that, they will be going through the new rule, and you may now be subject to more scrutiny when it comes to the public charge rule. This next update kind of flew under the radar. Unless you have this type of visa, you do not know this is happening. So if you have an F or a J visa, so F1, J1 visa. So when you're coming into the US, you are given a visa, either an F or J if you're a student. And typically when you come in, there is a stamp, and typically it says duration of status, or D/S. That means duration of status, meaning you can remain in the United States until you are no longer maintaining your status. So if you are enrolled in school and you continue to be enrolled in school, so for example, if you entered the US on an F1 visa to attend an undergraduate program, you finish that undergraduate program, you may do, OPT afterwards, or you may choose to go into a master's program. You will still be in F1 status because you still have duration of status, regardless of how long it takes for you to get that undergraduate degree, to then get your master's degree. And after your master's degree, you may want to get a PhD. And guess what? You are still in status as long as you are maintaining your enrollment in school. And you can still afford to pay for the school, because remember, as an international student, you do not qualify for financial aid. So you will still have to pay for that undergraduate, master's, and PhD program out of pocket, unless you are receiving some form of grant that is not government based in order to do that program. So that's how it has worked for a very, very long time. But on July 17th, the Department of Homeland Security issued a final rule ending duration of status, basically saying if you have F1 or J1 status, you are now going to be limited in your stay in the US up to 4 years. So when you're coming into the US on your F or J1 visa, you are now no longer going to get duration of status. You are going to get a set term for your stay in the US, and that term can be up to 4 years. After that 4 years is up, you need to make sure that you apply for an extension before the 4 years is up. Okay? If you do not apply for an extension, you are now officially out of status. It's really important that if you are on F or J1 visas, that you are paying attention to your I-94 before this. You did not need to pay attention to your I-94 because you had duration of status. You could, as long as you maintained your status as a student, you are able to remain in the US and not have to worry about filing an extension. But with this new rule, if you travel outside of the US on your F1 and you're coming back in just know that your second entry into the US, even if it's on the same F1 visa, can now be limited to 4 years. You are no longer going to get that duration of status starting September 15, 2026. So make sure if you are an international student and you are going to travel on your F1 visa outside of the US, when you're coming in, be aware that you are now going to be limited on your stay if it is on or after September 15, 2026. Also, if you are now limited, you need to pay attention to your I-94 because that is what's going to control. You look at your I-94 and pay attention to it because now you're going to need to file an extension before your duration of stay expires, okay? You need to file that extension because if you don't, you are now out of status. This rule also shortens the grace period from when you are done with your studies and when you have to leave the US. So make sure that you are paying attention, very close attention to your dates when it comes to your F1 status. Now let's talk about the H-1B because it has went through some things, okay? So the H-1B saga started in September of 2025 when the administration basically slapped on a $10,000 fee for each H-1B petition so that employers are now stuck paying $100,000 for each H-1B petition that they put in for their employees that won the H-1B lottery. Now, in June of 2026, a federal judge in Massachusetts, Judge Sorokin, actually ruled that the new fees are unconstitutional tax that only Congress can impose and vacated the fee. Then the government filed an appeal and asked that the Court of Appeals go ahead and give them a stay, meaning, hey, pause the ruling from this judge, Judge Sorokin, so that we can continue applying this rule. The circuit court justices said, no, we're not going to pause that decision because you have not proven to us that you are actually going to win your appeal. So there's no reason for us to pause this decision. Now we also have a decision from a district court in DC basically saying that the fees are constitutional and should be in place. But because the First Circuit Court already said no to a stay, that fee is still not being applied. So if you are an employer filing for your employee, at this moment, you do not have to worry about that fee. This will probably be a fight that goes up to the Supreme Court, and we will see if the Massachusetts judge and the First Circuit justices are correct, right? According to the Supreme Court. According to the law, may be different, but according to the Supreme Court, may be different. So we will need to wait and see. But if you have not filed, if you are an employer, and you have not filed the H-1B petition for your employee that won the lottery, unfortunately, the fiscal year 2027 cap has been met for the regular cap and the master's degree cap. So if you are applying for a cap-based H-1B, unfortunately, if you're not already in there, you are out of luck. Things may change, right? Because if you're in the H-1B world, you know that if there's denials or things like that, there may be open spots later on and USCIS may do another round. But as of right now, that cap is closed. Let's talk denaturalization because a lot of people have questions about this. So I want to make sure I update you on what the current status of it is, and it is not good. So on July 20th, the Justice Department and the Department of Homeland Security jointly announced new denaturalization actions against 10 naturalized citizens that are accused of different crimes. And the Department of Justice is explicitly calling this the largest denaturalization effort in US history. And guess what? The numbers back up that claim because it is the largest denaturalization effort in US history. According to internal guidance from USCIS, it directs USCIS to refer 100 to 200 denaturalization cases every single month, not year, month, with a fiscal year target of at least 250 of these cases being completed and people being denaturalized. So that's 100 to 200 referred for denaturalization and at least 250 denaturalized in the fiscal year. And again, the fiscal year runs from October of each year to September of the following year. So for comparison, during the first Trump administration, they averaged about 42 denaturalization cases a year. And during the Biden administration, they averaged about 16. One thing to keep in mind about denaturalization, it is not just a form that is signed off and now you are no longer a citizen. There is a process that the Justice Department has to go through in order to get someone denaturalized. And the government still needs to prove its case in court to get someone denaturalized. But the thing to note here is the scale of it. The scale of the denaturalization effort is historic. It is not the usual. So we need to pay attention to what's going on and who is being targeted. Now, let's talk TPS because there is a lot going on there between Haiti, Syria, Honduras, Nicaragua, Venezuela, Ukraine, Lebanon. Different rules are applying to different people. So we need to make sure that we are staying on top of it, okay? So as far as Haiti and Syria, the Supreme Court ruling basically ended that that TPS, okay? It is not being extended. The work permits have expired, and this is causing chaos for employers that are relying on TPS holders to basically staff their nursing homes, their work, right? They have all these employees that are now no longer able to work, and they have to fill all these roles. Again, that's almost 1 million people that have their TPS in jeopardy in the month of July, okay? Like, this is massive for employers. Like, literally massive for employers. For Honduras and Nicaragua, their termination for their TPS is still stuck in court. Although the Ninth Circuit already ordered a stay in favor of the government, it's still not final. So they're still in limbo, basically. For Venezuela, the TPS has ended for most people, although a narrow group of people that got their approvals in early 2025 are still able to keep their work permit through October 2nd, 2026. Again, narrow group of people. For Ukraine, a judge specifically ruled that the work permit extensions do not expire this July, as some had feared. So Ukraine TPS holders got a bit of good news. However, there's no like great news to be like, yes, this is when it's extended to. We're still waiting to see. Lebanon got a 6-month extension. Now their TPS is valid through late November 2026. We know that roughly 1 million people have had TPS protection stripped or put in jeopardy since 2025. And starting July 20th, House members are trying to get a discharge petition to force a vote on the Dream and Promise Act, which would create a path to permanent residency for Dreamers and TPS holders. Again, we'll see if that passes, but it is a long shot, but we need to hold on to anything we can at this point. And like I said, enforcement is still going on. ICE is still hitting high records. So ICE averaged around 1,600 arrests a day in July 2026. And yes, you heard that right, 1,600 arrests a day in July 2026, which is the highest pace in the agency's 23-year history. Okay, and they beat June's record of about 43,000 arrests in the month of June. July already beat that record. So as of a July 20th data release, ICE had carried out over 356,000 deportations in fiscal year 2026, which started back in October. Remember, the fiscal year is from October. So fiscal year that we're currently in is October 2025 to September 2026. So that's the fiscal year that we're looking at here. And Department of Homeland Security also says that roughly 70% of the recent arrests involve people with criminal charges or convictions. That's what they say. However, we in the immigration world know better, okay? We know better. So just keep that in mind. The next thing that I want to talk about is for my African countries, because if you don't know, me, myself, Nigerian, American, but the US consulates in Africa are consolidated. So there were US missions and consulates in different countries that were able to process visa applications. So those individual posts are now being consolidated into regional hubs. So for example, in Nigeria, we had 2 places where you can apply for a non-immigrant visa: the US Embassy in Abuja and the US Embassy in Lagos. The US Embassy in Abuja is being closed, and only the US Embassy in Lagos is now open. So now there is going to be 20 regional hubs. So these regional hubs are going to include the embassies and consulates in Abidjan, Accra, Addis Ababa, Cape Town, Dakar, Dar es Salaam, Djibouti, Johannesburg, Kampala, Kigali, Kinshasa, Lagos, Lomé, Luanda, Malabo, Monrovia, Nairobi, Port Louis, Praia, and Yaoundé. And then there will still be posts that provide American citizen services and limited non-immigrant visa services, but those again are going to be limited, very limited to American citizen services. So if you are not from one of these places that has a regional hub, you will get your interview in one of the regional hubs, and you will need to travel to that regional hub for your immigrant visa interview or your non-immigrant visa interview. So really a big shift for African countries. So if you are not from one of these countries, just know your embassy is now going to be one of these regionals, and you're probably not going to know which one until you have your interview. Okay, so we hope you have the funds to get to these regional hubs and attend your interview. And then just a few more things that are smaller, but I want to cover. The visa bulletin had major movements in the final action date chart. Watch my video from last week where I went over the August visa bulletin, because there were some major moves, and you need to know about it to make sure that if you are waiting for that preference category visa, that if your category has moved forward, that makes your visa priority date current, that you're moving very quickly to apply for that visa or your green card in the US if you qualify for adjustment of status in the US. And then finally, there is a $750 expedited visa appointment pilot program that the State Department is running through the end of the year. And this basically lets people jump the line by making a $750 payment to get their interviews expedited, not because they need it expedited, but because they have the money to get it expedited. So if you do not have the $750 to get your visa application expedited, oh well. And just to be clear, this is only for non-immigrant visas, does not apply to immigrant visas, okay? Really important, because sometimes we do want immigrant visas to be expedited, but you have to go through the regular expediting a visa process. But for non-immigrant visas, so if you're applying for a B1, B2 visa and you want to jump the line, pay the $750 and you may be able to jump the line. Please note that this does not speed up the decision. It speeds up your interview. So after you have your interview, if your case has to go through administrative processing, it still has to go through administrative processing. Paying the $750 does not change that fact. So I know that was a lot, but that is the July 2026 roundup. The Supreme Court decisions from June finally landing onto people's lives in July. A major green card rule is being rewritten as we go through. International students are facing system overhauls and a fee fight that's nowhere near over for H-1B applicants, and enforcement numbers are hitting record highs month over month. And one thing to keep in mind is most of these updates have litigation attached to it. So we have to pay attention to not just the update, but also the lawsuits that may be going along with it at the same time. If you want a country by country or category by category breakdown, let me know in the comments and I'll put one together. Although most of these updates are going through some form of litigation, it is important to note that September is going to be a big month for students because that's when the new duration of status changes happen. And two, September 18th is when the public charge rule changes for green card applicants. So that is going to be a big month for these rule changes. As always, if you would like a country by country breakdown, a category by category breakdown, let me know in the comments and I'll put one together for you. Subscribe if you want to track these changes monthly, because at this pace, there's going to be new changes every single month. At least that's what we have seen all year long. I hope this update has been helpful to you. If you're listening to it and you're like, oh my goodness, these are going to affect me in the future or my case right now, and you want a consultation to think through how this can affect you and what steps you can take and how I can help you take those steps, go ahead and schedule a consultation with me by going to my website, lilylegal.com, click on contact us, and you can pick a date and time that works best for you for us to chat about your case.